and welcome to a grand new episode of Legal Wrangle for Direct Tax. Grand because today we bring you 6 cases, all from the Supreme Court of India. These decisions relate to unabsorbed depreciation, rental income, Section 80 IB, principle of promissory estoppel, and allowability of levy under Section 43B when not actually paid before the expiry of the previous year, and finally the authorization of search under Section 132. Our first case is a Supreme Court decision where the court considered the fate of unabsorbed depreciation of earlier years which was carried forward, but the assessee claimed depreciation only for the current year. The question was whether the assessee's right not to claim unabsorbed depreciation allowance allows it to partly invoke Section 32 and bifurcate the unabsorbed depreciation allowance to claim only to the extent of the current year. The assessee is Seshasayee Paper Boards that manufactures paper. Let's go to Purnima for the facts.
The assessee had unabsorbed investment allowance of previous years as well as unabsorbed depreciation of earlier years. In its income tax return, however, it chose to carry forward investment allowance and claimed set-off of the unabsorbed investment allowance to the extent of its entire business income after exemptions, deductions and additions, declaring nil income. The assessee claimed the depreciation allowance insofar as it pertained to the current year and not to the unabsorbed depreciation allowance of the previous years. The revenue maintained that the assessee had to set off the unabsorbed depreciation of the earlier years first and then investment allowance. The assessee's entire unabsorbed depreciation of earlier years was thus adjusted.
All the assessee appeals were dismissed and the matter reached the apex court. The Supreme Court agreed that depreciation was a benefit which had to be specifically claimed by the assessee. But once claimed, did it give the assessee the right to split the provisions of Section 32? Let's see what the apex court held.
The Supreme Court held, by legal fiction, unabsorbed depreciation becomes depreciation of the year in question and gets added to the depreciation of the current year. Bifurcation of depreciation of current year from unabsorbed depreciation allowance is not permissible. The position would have been different if the assessee had not claimed any depreciation at all. Once depreciation is claimed, the entire depreciation is to be set off against the profits of the current year prior to the unabsorbed carried forward investment allowance.
Our next case is a Supreme Court decision in the case of Chennai Properties and Investments. The interesting question in this case was whether rental income received from leasing of property may be treated as business income when the assessee is in the business of real estate. Let's have the case details from Purnima.
Sure, Asha. The assessee is in the business of acquiring properties and letting them out. The assessee's entire income was from letting out of these properties. The assessee showed these receipts of rent as income from business. Revenue held that it was rental income which had to be treated as income from house property. The High Court upheld the revenue stand.
In further appeal by the assessee, the court considered the assessee company's memorandum of association and held in favor of the assessee. Let's see the details of the order.
The Supreme Court held letting out property is main object and business of assessee company. Assessee's entire income was from letting out properties. Assessee's rental income to be treated as income from business.
The Supreme Court did clarify that merely an entry in the object clause showing a particular object cannot be the determinative factor to conclude whether the income is to be treated as income from business, and such question would depend upon the circumstances of each case. Our next case is a Supreme Court decision which notes that the term housing project is not defined under the Income Tax Act for the purpose of Section 80 IB 10 deduction. The assessee is Veena Developers. The assessee had undertaken construction projects approved by the municipal authorities as housing projects. However, the assessee had also undertaken some commercial activity as a part of the housing project. The question before the court was whether Section 80IB deduction may be denied to the assessee due to the element of commercial activity. Let's hear the facts from Purnima.
Of course, Asha. The assessee's construction projects were approved by local authorities as housing projects. However, revenue disallowed the assessee's claim of Section 80IB deduction as it had undertaken some commercial activities too in these projects. While the tribunal restricted the Section 80IB deduction only to a part of the project, the High Court reversed the revenues order, holding that the expression housing project had to be given a grammatical meaning as it was not defined under the Income Tax Act for the purpose of Section 80IB.
The dispute reached the apex court that ruled in favor of the assessee. The court noted that the limits for commercial activity are prescribed in the development control regulations as framed by the local authority itself. Therefore, a project approved as a housing project by the local authority may provide for an element of commercial activity, but that was no reason to disallow the deduction. Let's see the details of the order.
The Supreme Court clarified that the Section 80IB subsection 10 deduction is permissible when project is a predominantly residential project and commercial activity in the residential unit is carried out to the extent permitted under the DC regulation framed by local authority.
The next case from the Supreme Court relates to the issue of whether a vend fee payable by the assessee to the state government as levy on its sugar mills was allowable as a deduction under Section 43B, even if the payment was not actually made before the expiry of the relevant previous year. The assessee in this case is Travancore Sugars and Chemicals, which is in the business of manufacture and sale of foreign liquor and sugar. Let's have the details of the case.
The state government had imposed a compulsory levy on the assessee's sugar mills, which would go into a fund to be used for repair and replacement of old machinery of these sugar mills, which was a benefit conferred by the state. However, this fee was not actually paid before the expiry of the relevant previous year. The assessing officer disallowed the vend fee under Section 43B as it was outstanding as a liability payable to the government of Kerala as on the last day of the accounting year. The appellate authorities deleted the disallowance and ruled in the favor of assessee. The High Court held that the vend fee was a privilege and was out of the purview of amended Section 43B.
The revenue appealed before the Supreme Court, which considered the provisions of Section 43B and ruled in favor of revenue. Let's look at the details of the judgment.
The Supreme Court held subclause A of Section 43B considerably widened by amendment with the addition of the words by whatever name called. Any sum payable as cess, fee, duty, tax or called by some other name becomes an allowable deduction provided that in the relevant previous year this sum was actually paid. Section 43B as amended is attracted even if vend fee is called privilege.
Our fifth Supreme Court decision is on the interesting question of whether a state is bound by the principles of promissory estoppel and cannot refuse extension of registration to the assessees that could not complete the project due to natural disasters. The assessees were multiplexes led by Devi Multiplex. In December 1995, the Gujarat government announced a scheme of incentives for tourism projects granting registered assessees a tax holiday from 5 to 10 years in the form of various exemptions from sales tax, turnover tax, electricity duty, luxury tax and entertainment tax up to 100% of capital investment. To avail these incentives, the assessees applied for temporary registration, which was granted, and the assessee started constructing the multiplex. Subsequently, the state government issued a resolution in June 2000 curtailing the operation of the scheme, which allowed an initial period of 2 years for going operational that was extendable by a further period of 2 years subject to satisfactory progress. However, the assessee's project completion was delayed due to Events like earthquake in Gujarat, communal riots and changes in building norms. Let's get more of the facts from Purnima.
The assessee applied for grant of extension for completing the project while declaring the expenditure incurred. The state level committee found that the delay in commencing and completion of operations was justifiable and the assessee's temporary registration certificate was stated to remain in force, making the project still eligible. The assessee commenced commercial operations and applied for grant of appropriate eligibility certificate in November 2003. Subsequently, a special civil application was filed by the Multiplex Association before the Gujarat High Court for grant of eligibility certificate for its members.
The High Court ruled in favor of the state government, holding that the operative period of the scheme ended in November 2000, by which time the assessees had not commenced commercial operations and were therefore not entitled to any benefits under the scheme. Sufficient time had also been given to the assessees for starting commercial activities, and further extension of time limit would lead to undue burden on the state's exchequer. Even the number of multiplexes was more than the requirement of the state. The High Court held that there could be no application of the principles of promissory estoppel and directed the assessees to keep paying the current taxes. The matter reached the Supreme Court, which ruled in favor of the assessees, holding that the state was bound by the principles of promissory estoppel. Let's have a look at the judgment.
The Supreme Court held core components of scheme had acquired statutory status. If state government wanted to amend the scheme, the government resolution ought to have been translated in a statutory notification. Curtailment of period and opportunity under scheme by subsequent government resolution is bad and ineffective. Assessee is entitled to have full benefit.
Our last case of this episode, the Supreme Court has ruled on the jurisdiction of the High Court under Section 226 of the Constitution in getting into the nitty-gritty details of sufficiency, adequacy and acceptability of reasons for authorizing a search under Section 132. The assessee in this case is Spacewood Furnishers. Let's go to Purnima for the case details.
The Assistant Director of Income Tax concluded that Spacewood Furnishers, its directors and associated enterprises overseas were suppressing income substantially, had undisclosed income and assets, and were not even likely to produce the details of its unaccounted income if issued notices under Section 131 or 142, and therefore it was a fit case for exercise of powers under Section 132. The Assistant Director prepared a detailed note with reasons which was put up for consideration before the Additional Director Investigation, the Director of Income Tax Investigation and the Director General of Income Tax Investigation for approving the issue of warrant of authorization for search of the residential and business premises of the assessee and its director. The matter reached the Delhi High Court that interdicted the block assessment of the assessee. The High Court considered the 4 satisfaction notes of 4 different authorities. It held that the Assistant Director was not the competent authority under Section 132. The Additional Director and the Director, who were competent authorities and had recorded their satisfaction, had not taken the final decision to issue the authorization, and each authority had passed the file to his immediate superior. Consequently, the High Court held that the satisfaction mandated by Section 132 was not that of the authority who had issued the search warrant, thereby vitiating the authorization issued.
The High Court also held that when the satisfaction recorded was justiciable, the documents pertaining to such satisfaction may be open for inspection by the assessee. The matter reached the Supreme Court, which held that the High Court's opinion was incorrect, as it would be counterproductive to the entire exercise contemplated by Section 132. The Apex Court allowed the revenue appeal. Let's have a look at the judgment.
The Supreme Court held recording of reasons ensures accountability and proper judicial assessment of revenue's decision. Only at the stage of commencement of the assessment, requisite material may be disclosed. High Court committed serious error in reproducing contents of satisfaction note containing reasons, confers undue advantage on assessee and frustrates revenue.
This brings us to an end of this episode of Legal Wrangle on Direct Tax. Thank you for staying with us and hope you enjoyed it. Remember, you can email us your comments, counsel and criticism at editor@tiol.in. Don't forget to subscribe to TIOL Tube channel on YouTube. See you again next week. Have a good day.